So I want to bring y'all this story. I brung it before and we talked about it before she was found guilty. Now today she was sentenced to 20 years and I want to go over the sentence. And I like the way they have a recording of the judge break down her sentence and say why she sentenced her to 20 years. Okay. This was a story that I did. It was back in 2025. It's of Latosha Daniels. This is the young lady that was in Arkansas that her pastor ex-lover, well, she was his mistress really, because he was married and she was married. So she was his mistress for 2 years. He sent her a text message breaking it off, basically saying, this is this will no longer work for us. She didn't like it. She brought a Pum that morning of and drove 3 hours to his residence in Memphis, Tennessee, or right outside of Memphis. I think it was right outside of Memphis. And they sat and talked for a while. The wife let her in until the husband arrived. And when the husband arrived, he basically was like, we need to walk her to her car. And as they were getting up and walking toward the door to lead her out to walk to her car, she Pum'd him, right? Emptied a clip and then turned around and reloaded and Pum the wife, but she did not kill the wife, okay? She only KI'd her husband, the man, okay? So today was her sentence, and a lot of people was like, well, was this a passion of crime? Because he did play on her. He played in her face. He basically told her that the wife knew about them and the wife was okay with them being sister wives. So she thought she was about to be a whole sister wife with the woman, and come to find out the wife claimed she didn't know nothing about the mistress. Like she never agreed to no sister wife situation. And yeah, I think she said all that to protect her husband's name or image. But my own opinion, I believe that the wife did know that her husband was cheating because he would go out of town on vacations and whatnot. And guess who would go with him? His mistress. But she wouldn't go like with him. She would meet him there. But nevertheless, the case went on and she was charged with first-degree murder, right? First degree. This is out of the state of Tennessee. She was charged with first-degree murder, but they were unable, even though she's on camera video purchasing the weapon the morning she took off and drove 3 hours, okay? So all of that's on video, and she admitted to the Pum, right? However, they were not able to find her guilty on first degree because they said they could not determine it was premeditated, okay? That it was not her intentions when she first bought the weapon and drove all the way to Memphis. Actually, there was a suicide note that she wrote basically saying that she was going to use the weapon to off herself, okay? But she didn't do that. She actually ended up Pum him, okay? And she got on the stand and she basically said that he broke her heart, okay? Because he had her fooled thinking that they had something when they really didn't, all right? So there is about a 28-minute video that I want to break down, and it's of the judge. And I think you guys are going to be very interested in this because I was interested in listening to it. So go grab you something to drink. I will be stopping and talking in between the 28-minute clip, but it literally breaks down why the judge made the decision that she made. And it's very much interesting. The reason I think it's interesting is because we do cover other court cases. We do have the Holly and the state of Illinois case that we'll be covering, and also the Carmelo Anthony case. And this kind of shed light on how the court sees these things, okay? It's a lot different than how we see things, how I see things, how you see things, how other people see things. The court sees it different. Well, I like the way this judge breaks it down. Now, I mean, I'm sure other judges break it down as well, but this was captured on video, okay? So it gives me an opportunity to look and see how the court sees things. So I think you would be interested. So go get you something to drink, get you some snacks, turn your volume up, and let's hear this judge explain why she gave this young lady 20 years for second degree, okay? She was found not guilty of first degree, but baby, they threw the book at her for second degree. So here we go, you guys. Here we go. Turn your volumes up.
Daniels is being sentenced for the crime she was convicted of. Let's take you now into listening to the judge.
So the first thing is to determine the sentencing range. And so the defense asks for an especially mitigated, that she be sentenced as a especially mitigated offender. And the state says that because the court finds an enhancement factor that should not be applied. According to Tennessee Code Annotated 40-35109, the court may find the defendant is an especially mitigated offender if one, the defendant has no prior felony convictions, with the defendant does not, and the court finds mitigating but no enhancement factors. In this case, the court does find an enhancement factor for the possession of a weapon. So the court finds that the defendant is not an especially mitigated offender. Therefore, the range of punishment on a second-degree murder would be 15 to 25 years, the standard range one offender, and reckless endangerment, a misdemeanor, that would carry 11 months and 29 days in jail.
Okay, so right there, I just want to point out to you guys, the first thing that she just spoke about is special mitigation, okay? So the defense was asking for special mitigation that would have given her the max of 13 years sentence, right? But the judge, by the way of the state said, no, we don't find that is special mitigated. And the judge agreed with the state and said, yep, because she did have a weapon, she does not qualify for the special mitigated, right? The judge said that the enhancement factor equal possession of a weapon, so she does not qualify, which means instead of max 13 years, her range would be 15 to 25 years. Okay, so basically they just bumped out that 13 year and they said, nah, you qualify for the next category, and that is the 15 to 25 year range. Okay.
And so one of the things the court has considered is the evidence presented at the trial and the sentencing hearing. And so the evidence at the trial was that the defendant was having an affair with a married pastor. And at the time, the defendant was also married. They had been in a relationship for about 2 years. The defendant and the victim spoke on the day of the murder. The defendant and the victim spoke on the confidence, where the victim told the defendant that their time had come to an end. And so after the defendant received that information, she went to a gun store. She purchased a gun in Sherwood, Arkansas. From the proof at trial, she's on camera, purchased the gun, giving the sales rep her ID, signing the paperwork that she needs. At the end, the defendant, when she was in Sherwood, Arkansas, drove to Memphis, which is over 2 hours from Sherwood, Arkansas, 2 hours from Memphis. And so the court finds that, the defendant's actions were deliberate. And although she wasn't found guilty of first-degree murder, her actions that she showed, and there was proof from Dr. Bidding that she had major depressive disorder, and also that she had some suicidal ideations. And that was the defense version of what happened. And obviously the jury rejected that. But also Dr. Bidding said that her conduct was, could be, even if you have depression, you can still be sequential, intentional, and deliberate in your actions, and it appears that way.
So right here, the judge is explaining that the defense tried to say that, yeah, she went and got the gun that morning. So yeah, it was deliberate, but she deals with depression and things of that nature. However, the same doctor said just because you are depressed or you deal with that mental illness or whatever, you still can be clear of what you're doing. Okay, even though you're depressed, depression does not stop you. It's not like what's the other what's the other one that the guy, they said he was out of his mind? What is that called? I can't think of that mental illness, but there's a mental illness that you're not in your right state of mind. But the doctor saying here that depression does not take you out of your right state of mind, that you know what you're doing. You can still be clear of what it is that you're doing. Okay.
To the court because the defendant drove over 2 hours, went to the victim's home, sat and talked with the victim, shot and disappeared several.
Not insanity. I think the word I'm looking for is schizophrenia. I think it's schizo, that you kind of be out of your mind. Sometimes like you can come in and out. So basically the doctor that weighed in on this case said, yes, she does suffer with depression, but depression does not stop you from having a clear mind. We're going to go back to that. Let's go to it. It said that it's, you know, she was depressed, but not psychotic or schizo.
Intentional and deliberate in your actions, and it appears that way to the court because the defendant drove over 2 hours, went to the victim's home, sat and talked with the victim, shot and disappeared several times, emptying the clip. And when the police arrived, she was attempting suicide, but during the entire course of that, the defendant possessed a weapon. Nothing, like Dr. Bennett said, she could still commit these actions even if she had a major depressive disorder. So the court finds that the nature and circumstance of the offense are serious. The victim was unarmed, and it really just comes down to the fact that the defendant said that the victim would not walk her to her car. And that's senseless, senseless to kill someone because he would not walk her to her car. And although the victim was a pastor who did not treat her right and he broke her heart, a broken heart does not justify someone dying. It just does not justify someone dying. It was just senseless. When typically when this happens, the relationship is over. Both parties go their separate ways. But in this case, the defendant killed the victim because her heart was broken. And so the court finds that the nature and circumstances of this offense warrant a lengthy sentence. Again, the statistical information shows that 19 years is a typical sentence for a standard range 1 offender, in the court would give that some consideration and look at the nature and circumstance of the offense. The court is going to give that great weight for a lengthy sentence. Also,
so right here, the judge is basically saying, listen, this was senseless. What you did, you unalived this man because he broke your heart. He wouldn't walk you to your car, right? So the judge is basically saying it doesn't matter if you were depressed. It doesn't matter, if he lied to you, if he played in your face, if he broke your heart. Y'all could have just went your own separate ways. He ended the relationship. You could have said deuces. He could have said deuces. And guess what? Nobody would be unalive. But you got mad, took matters into your own hand, purchased a weapon, and drove over 2 hours to his residence, sat down, spoke to his wife for a good bit. And then when he refused to walk you to your car, you unalive him. The judge says, no, that deserves a lengthy sentence. Okay. So basically she's saying, nuh-uh, we're not going for that. Oh, I was depressed. I was hurt. He really hurt me so bad. The judge like, nah. Even though they didn't find you first-degree murder, this deserves a lengthy sentence for what you did, okay?
Great weight for a lengthy sentence. Also, the court has to consider enhancement factors. And the first factor that the state raises is that the offense involved one or more victims. And the court finds that that factor does not apply. The fact that another person or persons are present when a crime is committed standing alone is not sufficient to trigger this factor. In this case, the two victims who were present in the home were Miss Perry and Mr. Perry. And the defendant was convicted separately for her conduct for each one of those victims. And so the court finds that that factor is not appropriate in this case. The other factor that...
Okay, so right there, you guys, the judge just rejected some of the enhancements. So the state wanted to charge her for the weapon enhancement because they're saying that it was two people involved, not just one. She unalived her ex-lover, but the wife was only just injured through gunshot, right? So she just rejected the enhancement, okay? It says that court rejected some of the enhancements, but applied firearm deadly weapon during the offense and gives it great weight. So she gave it great weight. So in the sentence, it's 20 years. She's given her 19 years for the KIN of the husband, but 1 year for shooting the wife, which is a misdemeanor. Okay, so she got a misdemeanor 1 year for shooting the wife and 19 for shooting the husband. All right, so let's continue. She gave it some weight, but she didn't throw the book at her for pew-pewing the wife.
The court finds that that factor is not appropriate in this case. The other factor that the state relies on is the personal injuries inflicted upon or the damage to the property sustained by or taken by the victims was particularly great. The court finds that it's not applicable to second-degree murder because it's inherent in the offense. It's an element of the offense. The injury was death, and so the court finds that that factor is not applicable. And then also the court finds it's not applicable to reckless endangerment because it has to be something that is over and beyond. Although the Ms. Perry said that she had pain at her shoulder, the court doesn't find that that is over and beyond what someone would be expected. The type of harm or injury that is greater than what is expected if someone was shot. So the court finds that factor is not applicable to this case. Next, the state asks for the enhancement that the defendant possessed or employed a firearm, explosive device, or other deadly weapon during the commission of the offense. And the court finds that this factor does apply, and the defense concedes that it does apply. But the defense asks that the court not give great weight to this factor. But second-degree murder can be accomplished without a weapon. And so the court is going to give that some weight. And the court finds this factor applies because the defendant was seen on camera purchasing a gun. The defendant drove to Memphis from Sherwood, Arkansas with the gun, went to the victim's house with the gun, shot Mr. Perry, killed him, emptied the clip, and shot Miss Perry. And when police arrived, she had the gun in her hand. So the court gives this factor.
So the defense was literally asking the judge to throw out the enhancement charge. They didn't say throw it out. They just asked the judge, don't give it no weight. Don't give the enhancement charge a weight. But the judge like, nope, we are going to give it weight because she did have a weapon. She purchased a weapon. She drove 3 hours with the weapon. She entered the home with the weapon. She fired the weapon on the husband and then turned around and fired the weapon on the wife. And when the police arrived, she was in the commission of trying to unalive herself. with the weapon. So she still had the weapon in her hand. So the judge is basically saying, no, we are going to give weight for her having a weapon. Okay. And that's what the reckless endangerment, the 11 months and 29 days come from. It is a misdemeanor, but they did still give it great weight. Okay.
Great weight against the defendant. She possessed the handgun throughout the entirety of carrying out this offense. So the court finds that that factor applies. So of course, given that great weight. Next, the defense filed for several mitigating factors. So the first factor that the mitigating factor that the defense raised, that the defendant acted under strong provocation. And I think the defense says that they were in a 2-year-long relationship, and she had a suicide attempt, and her word response to chaos and devastation with a disappearing text. And it was when he sent that text, she went into an emotional whiplash when he refused to walk her into her car. And at that time, she said, "You broke my heart." The court finds that that's not strong provocation because, again, yes, he did not treat her the way that she wanted to be treated. But also, Miss Daniels was in this relationship with the pastor.
Let's stop for a moment. So the defense is asking the judge to consider strong provocation, okay, to for her sentence, meaning that let's go over what provocation means. Provocation is something that the victim does that is so immediate and intense that it could make a reasonable person snap in that moment, okay, like a crime of passion, before they have time to cool off or think, all right? So in court, it is used to argue, yeah, what I did was wrong, but it happened in the heat of a moment because what was done to me right then and there, okay? So strong provocation usually look like being attacked or someone trying to seriously hurt you, all right? Or walking in and your spouse is in the act with another woman, or a sudden extreme confrontation that happens right then and there, not over a period of time. So they react like to something immediately, right? But what is not considered strong provocation is when someone break up with you, reject you, insult you, disrespect you, cheat on you, and you find out about it later. Then your feelings are hurt, you become embarrassed. You know, you claim they broke your heart, and then you go to the store, purchase a weapon, drive 3 hours, sit in the house, sit down and talk. You know what I'm saying? And then when they would not walk you to the car, all of a sudden you say you snap. So the judge is going to reject the strong provocation because the judge is basically saying, no, you did all of this. You had plenty of times to snap out of your snap, basically. So the judge is going to reject the strong provocation because the judge basically is saying, nah, this was something thought about and carried out, okay? So she had plenty of room or plenty of time to change her mind or just walk away. Or just not even, she literally had plenty of times to pull off on any exit and go back home, okay?
The pastor at the time, and although he didn't treat her, again, the way that she wanted to be treated, none of that was justified for Mr. Perry to be killed. And the thing that made her snap was that he refused to walk her to her car, which is very troubling. And so even though they had been in a 2-year relationship and he had not treated her as she was treated, the court finds that that's not strong provocation. That's just, I mean, I don't find that that's strong provocation. So the court is going to find that mitigating factor does not apply. substantial grounds.
So the mitigating factor, if she would have accepted that, then the sentence would have been lighter, okay? But she rejected the strong provocation, basically saying, nah, it's not good enough. What you did, you had plenty of times to stop or think about what it is you did. So it wasn't an immediate thing. You drove all that time thinking about your broken heart. So it wasn't like she just walked in a room and saw her, man engaged with another woman or something like that. Like it wasn't something immediately that made her snap. She didn't snap. She was just hurt and embarrassed and felt rejected.
It's tending to excuse or justify the defendant's criminal conduct, though failing to establish a defense. And the issue is the court doesn't find that substantial grounds exist tending to excuse or justify the defendant's criminal conduct. And the defendant testified that, and Dr. Fitton testified that she was suffering from a mental crisis at the time, where I think the defendant said, she was suffering from a mental crisis, and the defendant claimed that she was not in her right mind, and that the defendant also claimed that this should apply because she was in an affair with the defendant for 2 years, and he was manipulative. And so the court finds that the reason the court doesn't find that substantial grounds exist that would excuse the defendant's criminal conduct, because the court finds that the defendant was upset because he told her that the relationship was over and it didn't go the way that she wanted to, so she killed him. And so, again, Dr. Fitton said just because someone is suicidal does not mean that they cannot take deliberate actions. And the court finds that the actions that Ms. Daniels took on that day were deliberate, thoughtful, and intentional. And so
now it's interesting the way the judge is framing this, right? Because you heard her say that it was intentional, which that's the judge saying that. But a jury found her not guilty for first degree because they said they could not say that it was premeditated. So that's very interesting that the judge is using deliberate and intentional in her answer or response to whether or not mental health should be legally mitigated. So she's rejecting it because she's saying, again, just because you felt suicidal, just because you was depressed, just because you thought that he was a manipulator, it does not change the fact that you thought about this. You thought about this. This was intentional. It was deliberate. You made a decision when you walked into that gun store, purchased that weapon, and then you went to your car and drove. All right. You had plenty of time to think about that. So the judge is basically saying it was intentional and deliberate. Okay. So, I mean, it's interesting to hear the judge say this because she could have very well been sentenced for first degree. Sounds to me. Okay. All right. Let's go back just a little bit.
Deliberate, thoughtful, and intentional. And so she went and purchased a gun, gave her the ID, took the exit to Memphis, drove to the victim's home. And although he preyed on her insecurities, Ms. Daniels also was an active participant in the relationship. She knew he was married. She went and had lunch with his wife. But, although he preyed on her insecurities, she was also an active participant in this relationship.
Okay, very interesting right here, right? So the judge is basically saying, yeah, he manipulated you. He played on you, but you were a willing participant. You knew he was married. You knew he had a wife, right? So yeah, he played in your face. He may have lied to you, told you his wife knew about it. Y'all about to be sister wives and this, that, and the other. But this lady is 46 years old. So the judge is like, no, you took part in this. Like, come on. You know this man married. Like, you don't get with somebody that's married and then get mad when they don't want to leave their wife, when they tell you that the relationship is over. Because that's basically what happened, right? He wasn't going to leave his wife. So when he told her that he no longer wanted to be in a relationship with him, it hurt her feelings. And that does not justify KIing your ex or your lover or whatever, right? So she was a willing participant. So ladies, just know, ladies and gentlemen, hey, if you get involved in a relationship where you are the side piece or whatever, you know what you're doing. You know what you're getting into. Okay, so if it don't end up being perfect, don't go KIing nobody, all right?
Her insecurities, she was also an active participant in this relationship. So the court doesn't find that there's an excuse or justification for the defendants from a substantial ground this to justify the criminal conduct in this case. Also, the next factor, the defense raised, the defendant was suffering from mental or physical condition that significantly reduced the defendant's culpability for the offense. However, the voluntary use of intoxicant does not fall within this purview of this factor. And the law says that there has to be a causal connection between the offense and the condition. And Dr. Bidding's testimony was she couldn't say what her mens rea was at the time because the defendant didn't remember. And she said depression doesn't cause you not to make deliberate decisions. You can still be, she said that this Daniel's actions need to be sequential and goal-oriented. And actions suggest that she was able to plan and make judgments and that it was not a psychotic break where she was disorganized. She said, although she did say that her actions were contrary to her normal actions, but she could not say that a depressed person could not commit the actions of the defendant or that the depression would have specifically caused it. And so the court finds that based off that, the court's not going to find that the defendant was suffering from a mental or physical condition that significantly reduced the defendant's culpability for the offense. The next factor.
Okay, so right there, they hired a doctor to come in, and they do this because the state of mind is actually important when it comes to first-degree murder, intentional. Did you intend to do this? Was it premeditated? So state of mind is important. So they hired a psychologist to come in and testify, and they testified in the defense, testified on their behalf and said, yes, she does suffer with great depression. However, they said depression does not stop someone for being sequential, intentional, or deliberate. Okay. So again, it is not like she was psychotic. It's not like she was schizophrenic. She was depressed. Yes, she was, right? And depression does make you do things that you would not normally do. Okay. So depression does go against doing something outside of your normal behavior, but it does not stop you from being intentional, deliberate, or sequential, meaning that she knew what she was doing. Depression don't stop you from being out of your mind. You still know what you're doing, even though you're depressed. Okay? Thank you guys so much for the support. I do appreciate you guys. Thank you so much, Barbara. Appreciate that. So even though the psychologist came in on behalf of the defense, they have to be truthful with the questions that they're asked, right? And in this question, they were asked, did she suffer from great depression? Yes, she did. Does that stop a person from being intentional, deliberate, planning, knowing what they're doing? The doctor said, no, it does not. Okay. So weight was given there, and that was not, the judge did not buy that. Okay.
Basically reduce the defendant's culpability for the offense. The next factor the defense asks the court to consider is the defendant, although guilty of the crime, committed the offense under such unusual circumstances that a sustained intent to violate the law motivate the criminal conduct. It is unlikely that a sustained intent to violate the law motivated the criminal conduct. And the court finds that this does apply because according to the letters that were written by, I think, over 20 something character letters, most people said that this was outside the norm for Miss Daniels. And I don't think that she would probably do this again. I think that this is aberrant behavior. This is something where she was upset that the relationship was over and just kind of lost control of her actions. So the court does find that that factor is applicable.
Okay, so right here, this mitigation was accepted. Okay, so the judge does apply this factor, this mitigation factor, that this was outside her normal behavior and she will be unlikely to do something like this again. All right, so this mitigation was basically saying unusual circumstances, unlikely to reoffend. So the courts did accept that one. All right. So, normally the range would have been 19 to 25 years. This might be, not 19, I'm sorry, 15 to 25 years. This might be why the judge gave her the 19 years instead of the 25 years that she could have received, because they did accept this mitigation and that this is outside of her normal behavior and she probably would never do something like this again.
Yes. And so I think there was a case where a defendant had never been arrested. She had no criminal history. And he was essentially a law-abiding citizen. And so the court does find that that factor applies. The commission of offense unlikeness, there was a substantial intent to violate the law's motivation. The court just finds that her heart was broken and she just lost control of herself. So the court does find that factor. The court's going to give that some weight for mitigation. Remorse, the court does find that the defendant is remorseful. Her testimony today, she was very tearful. She apologized to victim's family for her actions.
So right here, the judge is actually giving them weight for remorse. Okay. So she gets remorse credit, right? Because she apologized to the family. She was crying. She was very tearful. She showed remorse in court. So she will receive remorse credit toward the mitigation, toward her sentencing as well.
And the court credits that, and the court will give that a little weight. No criminal history. The court's not going to find that for mitigation, but the court is going to give that some weight when we look at the lack or potential of rehabilitation. The court's going to give that some weight in her favor. She also wrote 8 books, so the court does find there is a potential for rehabilitation.
So right here, the judge basically saying, I do believe that she can be rehabilitated, right? But still slams her because she basically saying she could be rehabilitated in 20 years. You know what I'm saying? Which is a long, long time. But let's continue.
And that she completed all those courses since she's been incarcerated. The court's gonna give that some weight in her favor. When we look at the evidence at the sentencing hearing, we heard from 2 family members, the son and sister cousin of the defendant, who talked about how the character of the defendant, and the court is going to give that some weight in Ms. Daniels' favor. And again, the court does find that Ms. Daniels is remorseful. Validating risk and needs for sentencing, the court, I think the report says it is slow, and the court is taking that into consideration, but she does have moderate or mental health attitudes and behavior, which has been the case throughout. also, I think one of the things was the employment history. And the court's going to give that some weight in her favor as well when I look back for potential of rehabilitation. The court's not going to find it as a mitigating factor because the case law says that the fact that a person has a fairly stable employment history does not entitle the person to a reduction in sentence because every citizen in this state is expected to have a stable work history. If the economy permits the citizen to work and the citizen is not disabled or the citizen is not independently wealthy. So the court is going to take that into consideration when we look at her potential or lack of rehabilitation.
So just right here, because she has worked, she was actually if I'm not mistaken, a behavior specialist of something of that sort. Okay. That was like her job. She actually worked as in the psychology field, right? So, but the judge is weighing her employment history as a mitigating factor for her sentence, toward her sentence for rehabilitation. They look at that type of stuff and say, like, can you be rehabilitated? And once you come out, can you apply yourself properly and things of that sort? So her employment history, the judge is giving it weight for rehabilitation as well.
And of course, going to do the same for work history. So the court has to also look at the pre-sentence report, and again, she has no criminal history, which is good. She graduated from high school, went to college, received her doctorate as community service.
She received a doctorate? What the hell is wrong with this girl? Damn, hold on. She had a doctorate degree? Let's go back. What?
She graduated from high school, went to college, and
whoa, this is crazy.
In the charges, she still was able to obtain employment and then continue on with her community service projects and her nonprofit. So the court's going to give that some weight. Wow. She also has substantial family support, all things that are
this is sad. I mean, so sad. Oh man, over a man. Oh man, that's crazy. Crazy.
She also has substantial family support, all things that are beneficial to the defendant in looking at her potential or lack of potential of rehabilitation.
She received her doctorate and wrote 8 books since she's been incarcerated, right? For 7 years. She's written 8 books. Like, how do you throw your life away like that? But let's continue. We're going to get into that in a minute.
And also, of course, considering the statements of the defendant and the proof at the sentencing hearing. So in considering all those things and weighing all those factors on the reckless endangerment, the court is going to sentence the defendant to 11 months and 29 days in jail.
So for the reckless endangerment, for shooting the wife, she gets 11 months and 29 days locked up, okay? For shooting the wife, 11 months, 29 days.
The second degree murder, the court's going to sentence the defendant to 20 years. So that's going to be
So 20 years, but I think she's going to come back and change it to 19, but let's hold our horses. I think that's what I heard her say. But she said 20 years, but let's hear what she's saying.
20 years at 100%.
Oh,
So that's
did she say 20 years at 100%? Hold on.
going to be the order of the court.
Your Honor, may I ask for some clarification
Yes.
for appellate purposes? As to the mitigating factor regarding a positive work history, for employment, you said that you were looking at that regarding rehabilitation, but not a mitigator. For work history, you said you were looking at that regarding potential for rehabilitation. Did you also find that as a mitigator?
I didn't find it a mitigator, but I gave it weight in her favor for
And the community service, is that also considered as potential for rehabilitation, not as a mitigator?
yes,
The educational background,
yes. I'll give them weight for potential unbanked rehabilitation.
okay, but not as a mitigator.
Yeah.
And her book, the writing of the books, you lean towards potential for rehabilitation, not as a mitigator. And the strong R, the low risk for recidivism,
I gave it some weight in her favor.
as towards potential for rehabilitation or as a mitigator.
Potential for rehabilitation.
Thank you, Your Honor.
Anything else on the part? All right, well, we'll show that Tennessee here.
Your Honor, I have an order prepared, if I may pass it forward, just making very clear that this has been predated the truth in sentencing. She is eligible for the 15% credit. I think it's helpful for TDOC to have that outlined.
So what the defense attorney just did is submitted a form where she's saying that her client should be eligible for 15% good credit, okay? Which means that instead of 100%, 20 years, 100%, that she could possibly be eligible for the 15% good credit, okay? All right, let's see what the judge says about it.
Judge Stanley was also indicted 1904363 escape from misdemeanor incarceration, assault, and resisting official detention. It's related to incidents that took place immediately after this was done, based on the results of this case, and that the state is going to ask the court to show there's no prosecuted cost. I will pass court judgments on those. I will also be, if the court recalls, this case was superseded by indictment. So 19-04676 is still open. I will be passing forward orders on prosecuting all three counts in that. And then we have prepared judgments for the court to look at to make sure that they comply with what the court had to sort on those. I think I'm ready to pass all three sets of those up currently.
And Your Honor, just for the clarity of the record, those two counts are to run concurrently.
Yes, concurrent. Yes.
Okay, so the defense just clarified that those two counts will run concurrently, okay? Instead of consecutively, right behind each other, it's gonna be right beside each other concurrently, all right? So she won't have to do 20 years and then turn around and do 11 months and 29 days. It's gonna be done together. Which makes her total time 20 years. Now on this part coming up right here, I find this very interesting because the judge is pretty much going to say, listen, I could have given you 25 years because with the evidence and everything, what you did was enough to convict you on first-degree murder, but they didn't convict you on first degree. They convicted you on second degree. So you're really catching a break here. Just take a listen.
I also want to put on the record, I think one of the things that the state raised was the fact that I could, that there were enough actions for first degree murder based off her conduct. And so the court is given that some consideration as to why the court did not do 25, because the court can look behind what she was convicted of, and the court can consider the actions of the defendant. And again, the court does find that there was sufficient proof for the defendant to be found guilty. Her actions were premeditated, I guess that's what I'm saying.
Now, this is very interesting. This is very interesting because the judge is basically saying, even though the jury did not convict you on first degree, your actions, there is enough evidence to prove that your actions was of someone that committed a first degree murder. Okay. So she's basically saying, I could have gave you the book. Like, I could have threw it all. The stove, the refrigerator, the cat, dog, and the kids. I could have threw everything at you, okay? But, I'm giving you a little weight here, all right? So instead of 25 years, she gave her 20 years, but dang. So I'm only saying this because I thought that if they didn't find you guilty of first degree, then first degree is totally off the table. But the judge basically saying, just because they didn't convict you of first degree, I could have sentenced you as first degree because we got enough proof here. And if they would have done a bench trial, I believe this judge would have found her guilty of first degree murder. That's what it sounds like to me. What about you guys down below? All right, I'm backing it up just a little bit.
And then again, the court does find that there was sufficient proof for the defendant to be found guilty. Her actions were premeditated, I guess that's what I'm saying. So, with that being said, the court didn't do 25, and I think that the state asked for a higher end sentence. The court sentenced her at 20 years. So, again, the nature and circumstances of the offense warranted a lengthy sentence in this case. So.
And that's important for appeals, okay? Because basically she's saying, there is enough evidence to find her guilty of first degree. So she kind of getting off a little light. But the defense is not going to buy that. They're still going to do an appeal, I'm sure. But the judge is basically saying tread lightly because, she definitely could have been found guilty of first degree.
You're going to be the excuse for that.
Yes.
Thank you.
That has to hurt. So let's go over the amount of years, okay? So she got 20 years. If they give her the 15%, which in the state of Tennessee, you are eligible for the 15% credit. Let me see. It says second degree murder in Tennessee is classified as a violent offense. For violent offenses in Tennessee, it requires you to do 85% of your time. Okay, this means a person must serve at least 85% of their sentence before release eligibility. Okay, so once they serve 85%, she'll go before the parole board to see if she qualifies for that 15%. Okay, she has to earn it though. It's not automatically given. It has to be earned. All right, so it says you can earn up to 15% sentence reduction credit, but you still must serve a minimum of 85%. So let's talk about that. If she got 20 years, at 17-year mark, she'll be eligible for parole, okay? At the 17-year mark, And she's been in since 2019, which is 7 years. So she's looking at 10 more years. She's looking at 10 more years, and that's if she is eligible come the 17-year mark, okay? So come the 17-year mark, if she's still dressed, still doing what it is that she's supposed to be doing, not getting in trouble, things of that nature, and they give her the 15%, then she's looking at spending additional 10 more years in prison, all right? And that's if everything goes right. But it says the judge sometimes says 100% loosely, but legally for second-degree murder in the state of Tennessee, it is 85% service unless something unusual happens. So even though the judge did say 20 years, 100%, because they didn't find her first degree and they found her second degree, then in the state of Tennessee, the 85% is the minimum, and she does qualify for the 15% credit. Does not mean she's going to get it, but she does qualify for it. As long as everything goes well, she'll be getting out in about 10 more years. Let's finish up the last little bit. I think the reporter's going to say something. Okay. Oh, hold on.
The sentencing of Latasha Daniels. She was convicted of second-degree murder and reckless endangerment in the death of Pastor Brodus Perry and the injury of his wife. The sentencing has come down as follows: 20 years for the second-degree murder charge. She will also receive 11 months and 29 days for the reckless endangerment charge. Those will run concurrently, so her total sentence will be the 20 years in prison at this point.
20 years, you guys, 20 years. It was interesting that the judge basically said that she could have been found guilty. There was enough evidence of her actions and everything to give her first degree, but the jury gave her second degree. So basically, they're saying that she got off a little bit. What do y'all think? Do you agree with the judge that this could have very well been a first-degree murder conviction? I agree. And the reason being is because, listen to everything that she did. She purchased the weapon that day, okay? I understand broken hearts and all of that, but baby, child, that's why you need you a friend to call you up on the phone, and I don't know why nobody called her in 3 hours and told her if she don't take her goofy ass home, somebody should have told her to turn around. Don't do it, okay? But if you think about it, she planned it. You don't get on the road on a highway and drive that far, right? And you don't know what you're doing. So she planned it. She may not have, she may not have thought about it like how it was going to go down. But I believe that she knew that it was going to be a life taken that day, okay? Or an attempt life taken, okay? I believe that she knew that there was going to be an attempt. So in this case, this young lady has already been in prison for 7 years. And right now she's going to have to do about 10 more. About 10 more. Now her son cried in court. He did like a credibility speech, trying to give his mom some credit, saying that, she's a good mom, she's the best mom, and so forth and so on. But that was not good enough for the judge in the court. They said, okay, we get it, but her actions is definitely deserving of a lengthy sentence. So the defense wanted her to have 13 years, which means that by her already serving 7, she would have had to do 6 more. Actually, no, if they wanted 13 years, hold on, let me ask. If the defense, okay, hold on. Wanted 13 years. So I think that they said that because they probably wanted her out. So, oh, okay. So they were asking for 13 years. Okay. and she's already done 7. And then with the 15% that would have applied, she would have only had 4 more years to serve 4 more years instead of 10. So they were asking for 13 at the max. And the judge says no, gave her 20. But if they would have gotten what they wanted, the 13 years, she's already served 7, then she would have only had to do 4 more years. Okay. That is why they wanted the 13. But yeah, that didn't happen. That definitely didn't happen. All right. So she would have had to do, she would have 4 years left to serve. Okay. Yep. So anyway, but that didn't happen. That did not happen. So she said she's been locked up since 2019. Yes, she's been this happened in 2019. So yes, she was locked up ever since 2019. She had a trial. No, hold on. Did they? Because I think they already found her not guilty, didn't they? Hold on. Previously. It was something that was stalling her trial. Let me see. What was stalling? So no. So they did not have a trial. What happened was it was a pre-trial motion hearing, okay? It went through a pre-trial motion hearing, and there was a lot of delays. And it said the case eventually went to one jury trial where she was convicted of second-degree reckless endangerment. There was no prior complete trial that ended in a verdict. It says the long gap between 2019 and sentencing in 2006 was due to pretrial litigations, motions. A lot of motion was filed, scheduling delayed because of COVID, and then sentencing hearing. So that's why it took so long, because of COVID, and they went through pretrial motions and hearings and things of that nature. So, and then COVID happened, so it threw them back then. But she's been in jail for the entire 7 years. Hold on. So she was not released on bond. Yeah, she was not released on bond. She remained in custody awaiting trial the entire time. Yeah. It says in the state of Tennessee, when someone is charged with first-degree murder, bond is typically either denied outright or set extremely high and difficult to obtain. So we don't know if it's because she couldn't afford it, because it's set so high, or they just did not offer it. I mean, they just denied it. You know what I'm saying? So that's for the state of Tennessee. So she's been serving her time since 2019, and yes, she will get time credit served. So this is crazy. Unfortunately, I did not know this young lady had a damn doctorate degree. What do we say about that, you guys? She had a high school education, a college education, and she had her doctorate. She wrote 8 books. What do we say about women that have their life together educationally, financially, and they still find themselves doing something like this? What in the world can we say about something like this? At 46 years old, mind you. Now she's 46 today. I think she was 40? She was 39 when it happened, okay? So 39 when it happened, and she's 46 years old now. She'll be 56 by the time she gets out. I don't know. Sounds like she may have to start all over, you know? Crazy work, crazy work. She had 2 hours of driving to change her mind. Yes, Kathleen, I say that 2 hours of driving, and I don't know no one that drives for 2 hours and don't speak to nobody on the phone. I don't do that. Do you guys do that? I will not drive no 2 hours and don't speak to nobody. Nah. She says, never know someone's breaking point. I understand breaking points, but if he was close enough to where she just rolled over his house in a 15-minute time span or whatever, that would be different. But for 2.5 hours, you got enough time to think about what it is that you're doing. That's my opinion. You have time to think. I mean, she purchased the weapon from Arkansas. Okay. She purchased the weapon from Arkansas. So she purchased the weapon before she even got in the car. She had plenty of times to come to her senses and think about it. She said women need to normalize walking away from these men. Yeah, they need to. Thank you so much, Rita. Thank you, guys. Yeah, they need to normalize walking away before they do snap, before they do find themselves in a situation such as this one. She said, did she kill the wife too? No, she shot the wife. She did not KI her. You know, it was said that she was going to, and the wife kind of begged for her life. The wife told her to just leave and that she would not report that she did it. Okay. So, but no, she did not K the wife. I think she only shot her one time. Let me find out. I think she only shot her one time. I think it was one time, and she said that the reason why single gunshot. So it was only a single gunshot to the wife, right? She shot the man multiple times. She emptied the clip on that joker. But as far as the wife, she only shot her one time, and she shot her in the shoulder. And she said it was because she was down there helping him, but she said that she didn't really mean to, you know. So she was like, I didn't mean to. It kind of like just happened, you know. So she did shoot her. She said, I think she was covering the husband. Yeah, like she was over there doing something. She was bent down doing something to the husband, and Latosha shot her one time. She said, this goes to show you just never know people's mental state. That's true. You never know people's mental state, no matter how smart they are, how educated they are, how much money they make. Because this lady definitely didn't seem like she needed this pastor in her life. However, you know, it doesn't matter your education or your beauty or how much money you make. You still can make some badass decisions. And she made a badass decision in 2019. Okay. Hold on. I'm curious to find out, did she have a doctorate degree before or afterwards? All right, it says, yes, according to the judge's statement, during the sentencing, she did earn a doctorate degree. It says she graduated high school, went to college, received her doctorate, had employment history, was involved in community service and nonprofit. So she did have her doctorate degree. What do y'all think about that? Like, wow, I'm just blown away, like, lady. And it was in psychology or something. And the degree wasn't in psychology, but it was something along those lines. Like she worked as some type of behavior analysis or behavior case manager or something. It's something dealing with behavior. You know, they actually say people that work in fields like that do suffer from depression. Interesting. They suffer from their own mental health issues while they are assisting the mental health. She said the judge probably said you had this high level of education and knew better. I see what you're saying. So the judge is basically saying, listen, you can't pretend that you didn't know what you were doing. You absolutely knew what you were doing. So anyway, but yep, she got sentenced today to 20 years. So, you know, she's officially, well, she was already on the clock, but this one right here, she knows that she's not getting out no time soon. They did not take a lot of the things that the defense was asking for them to take into consideration. They were not taking those things into consideration. The things that they did take into consideration was very small, like, oh, she was remorseful, oh yeah, she may never do this again. But, but the judge said something very powerful, and that is basically your actions could have definitely got you sentenced to first degree. Okay. So 20 years, take that as a gift, basically, is what she's saying. Now, let's just listen to what the defense attorney. Let's listen to what the defense attorney had to say after court, okay? Because they are going to appeal. Y'all know that's always something that they do. Let's listen to what they had to say.
I'm with Latasha Daniels' defense team. Can you just break down your overall reaction to the sentencing today?
Overall, we were hoping for a lesser sentence. The offense carries between 15 and 25 years for a standard range 1 offender. We believe and still believe that Ms. Daniels is as mitigated as you can be. She has just always lived her life above and beyond outside of the events of April the 4th.
Yeah, and again, we've been doing this for a long time, and just to see the level of work that she did on herself, the level of work that she's done in the community, the level of work that she's done in trying to write books to help other families that are going through this. I mean, it truly shows that, one, she is rehabilitative, and two, that she's not going to recommit another offense. And so we were just hoping and optimistic that we would have got a sentence lower than 20 years.
Absolutely. And I saw that you guys, after that sentencing, took her to a different place and you spoke to her about it. Can you just speak on how she's feeling right now?
I think she's sad, disappointed.
She's definitely very emotional. This was a circumstance that was just a culmination of emotional distress and a mental health crisis. And it just does not define who she is. And she knows that. And so trying to square that with what the judge was saying today and who she knows that she is. And that doesn't necessarily equal what she heard as the perception of her today.
I'm Ezekiel.
Okay, so as we just heard, the defense attorney, they're disappointed because they wanted a lesser sentence, of course, and they really, really felt like it should have been a lesser sentence, okay? That she should have been mitigated with the circumstances, him being a pastor, him being a leader, him someone that she went to for counseling. Because I don't know if I told y'all that. I don't know if y'all heard my first video on this. She actually sought this man out for counseling for her own marriage, okay? Her marriage was falling apart, and she sought out spiritual counseling. And the second counseling session, they were having sex, okay? So he was staring at her in a desirable way. She's like, what are you looking at? And he was like, basically, I want you, in so many words, okay? And one thing led to another. They were humping, okay, on session two. So she feels that she was taken advantage of because, she went to him for spiritual counseling, and yeah, he gave her some spiritual D. All right, some spiritual D. So she fell for the okie doke. She was already, down, depressed, going through her own sorrows. And yeah, he got her at a very vulnerable time. I just wish she had one friend that could have helped her through this, talking her down and letting her know that, girl, you are so much better. You are more worthy than this bull crap. Okay. I wish she would have had one friend that would have told her something different, However, yeah, but being manipulated does not stop you from making good decisions. And apparently she made a bad decision, and that is what she's sentenced for 20 years for. I was reading, y'all. Sorry about that. She said, is this the case where the mistress unalived the pastor? Yes. This is the case where the mistress unalived the pastor, went to his home, spoke to his wife, had lunch with them. And, you know, when he told his wife to walk her out, she got upset because she felt like, damn, you know, you don't want me no more. He lied to her and told her that the wife knew that they were together and the wife agreed to be a sister wife with her. So she thought she was about to be a whole sister wife. And the wife said, nah, I ain't know nothing about that. Okay. I didn't know anything about that. Let me pull something else up right quick. You guys, hold on. Anyway, but Tabitha was her name. But I don't know if she testified. I don't see it where it says she testified in the case. I would assume that she would have, but I don't see it. So she said, it still don't add up to me how when she went to the house and the wife called him and said, I have a surprise for you. Oh, you mean it doesn't add up, meaning that she didn't know? Is that what you're saying? That the wife didn't know? The wife said she didn't know, but I'm just gonna say it like this. I just be believing that these wives know. They know when their husband is cheating. They may pretend that they don't know, but I just have a feeling that they be knowing and they deliberately turn a blind eye, or they just say they didn't know for the public. But I think that she knew and probably was arguing with him about it. I just don't believe that the wife did not know at all. But, you know, it would be very embarrassing to know that your husband is cheating on you. It's embarrassing for other people to know. She said the wife did testify. I think it was earlier. I'm looking for her part and I don't see it. I don't see her part. I don't even see what she actually said. Hold on. It just said she was inside the home when Daniels arrived. She described a confrontation between Daniels and her husband. She testified that Daniels shot her husband multiple times. She herself was shot and injured in her shoulder. She survived and was treated for her injuries. She said that her husband was unarmed, that the shooting was not self-defense, and that Daniels brought the weapon into her home. Okay. She said, yeah, the wife stated that she didn't know they were going out together. She knew for sure. Exactly. Yeah, the wife said she didn't know, but yeah, you know, I just find that hard to believe. Your husband is going on these trips and you're not with him and things of that nature. I don't know. I just be thinking, and her husband was a pastor, but he hung out in bars and little, you know, after hour drinking spots and things of that nature. So, you know, I don't know what's up with these pastors. They be on the prowl, baby. Not all of them, but some of them, honey. Some of these pastors be on the prowl. So that's why I find it hard for the wife not to have known. However, you know, we can't blame her per se. She didn't do anything wrong in this situation. So we're not going to blame Miss Tabitha, but because she is a victim, she was shot herself. She had nothing to do with a little affair or whatever. She lost her husband and she was also shot herself. So I'm sure she was pretty okay with the 20-year sentence because, yeah, she unalived her husband, took away that whole, you know, she probably changed his life's world. I mean, this wife's world. She changed her world. She was the first lady. Now, you know, she's a widow. So I'm sure she was there for the sentencing and, you know, and was pretty okay with the 20 years. So anyway, but that's it, you guys. I literally just wanted to bring you guys this story. If y'all don't have any other questions, we're going to end this live stream. This wasn't going to be a long one. It's literally just an update on a story that we already covered. But she was found guilty of second degree and sentenced for the second degree. But I put the title beat first degree, but sentence on second degree. And I did that because a lot of people think that if you're charged with first degree, you're going to be found guilty of first degree. And that's just not the case here. But it was interesting to hear the judge say, even though she was not found guilty of first degree, her actions, evidence shows that her actions is pretty much first degree. Okay. So you may not, the jury may not always come back, right? Because they can't agree that it was premeditated. collectively, right? All 12 of them can't say, yeah, it was premeditated. However, in sentencing, the judge have liberty to say, yeah. Well, the evidence definitely showed that this was first degree. So I'm gonna put some weight on that sentence, because you very well could have be facing 25 years to life, right? But since the jury came back and said second degree, I'm gonna, give you a little bit more time or whatever, because your action was definitely not someone that didn't know what they were doing. Interesting case, okay? Interesting case. When I see cases like this, I try to apply them to the Holly and Ramika case, and that's why I tell people it's I'm not gonna say impossible, but it's difficult. It's difficult without video footage and evidence and things of that nature to find someone guilty of first degree. And the reason being is because first degree, it is based on mindset. It's based on mindset. And it's hard to prove what type of mindset a person was in the day they chose to do what they did. Okay? Mindset is hard to read, So that's why sometimes they like to see video footage to see what led up to it, like, the whole actions or whatnot. But nevertheless, we'll continue to break down these stories. Y'all know we got the Carmelo Anthony coming up in June. I know it seems like a while away, but baby, we about to be in March next week, okay? We about to be in March next week. So June is definitely right around the corner. So we will be tapping into that case. And I'm pretty sure there's going to be quite a few other bloggers blogging on the Carmelo Anthony. So that would be an interesting case to follow as well. So anyway, thank y'all for pulling up. I do appreciate the love. Thank you, Troy, so very much. Binky Bink, love. Thank you so much. Thank you, Barbara, in a big way. Thank you so very much. Thank you, Lacondas. Thank you, Binky Bink. And thank you, Rita. Appreciate you guys so very much. I'm going to sign off and take me a bubble bath because I told y'all I wasn't really feeling all that great. And I'm going to rest for the rest of the evening. But I will talk to you guys on Hump Day, and that is tomorrow, you guys. Y'all be good out there in these internet streets, all right? And if you hear my voice, for those that's going to replay this and watch it later, just comment replay in the comments, okay? Thank y'all. Talk to y'all soon. Good night.
Because they can't make $1 without mentioning down one of our names.
Jay!
She kept talking about
We
that
got these
family.
hoes over there.
She kept talking about that family. She kept talking
Internet
about that
gangsters.
family. She kept talking about that family. She kept talking about that family. That family. She kept talking about that family. Talking about that family.
These motherfuckers don't be wanting to listen. Because they can't make $1 without mentioning